Hello and welcome to the Kenneth Verkema Law Office Legal Podcast. In this edition, we look at the signing of the last will and testament. Let's see. In most law offices, after the person meets with the attorney will draft the documents and then send out the documents to their client for their review. Now, oftentimes the attorney will indicate in their letter that if there's any revisions or modifications, they don't want to take the revisions or modifications over the telephone. Typically, at least in my law office in Edison, New Jersey, we will ask the client to take, if there's minor changes, take the draft of the will or the document, mark up the changes with a pen, and then fax or mail those back to our office a few days prior to the office signing. It's important to indicate in the letter to clients by attorneys that RPC 1:6 prohibits our office from discussing the will or other matters with family members or anyone other than that person. I recall in the past where my wife would say, "Hey, how come you didn't tell me that my uncle came in to see you?" And I says, "Well, I can't. It's confidential. I can't discuss things with you that deal with your family." She goes, "Well, it's my uncle." I goes, "Well, but if it deals with the law office, I can't discuss with you." It's also important to put in writing to the clients that joint accounts go directly to whoever the beneficiary is, that the will cannot change who the beneficiary is in a joint account. The will can't change who the beneficiary is in a will. Other issues that the attorney must look at is the issue of competency. And I recall one client or potential client called up and he said, "Listen, my dad needs a new will, power of attorney, and he wants to sign the house over to me." I said, "Great, when can your dad come in?" And the answer was, "Well, Dad can't. Dad has a bad leg, can't get around much, but can he come out to the office or to the house?" We said, "Of course we can come to the house. We're willing to work with new clients." So go to the house, and I remember it's the first nice day of spring, and in April, snow's melted, the robins are chirping, and it's a nice day, sunny out, and I go to the house, and the son's waiting outside. The son did not live with the dad. I go into the house, and the son goes to the dad, "Now, Dad, this is an attorney, and he's going to explain to you why you should sign the house over to me." The old man looks up and says, "I'm not going to sign the house over to you. You'll kick me out and sell it." And that's when I realized that the son never told the father. So typically nowadays, most attorneys, if someone can't come into the office and has some health concerns, they're willing to help the people out. But at least in my office in Edison, we want, number one, a certification or a note signed by the doctor saying that they're competent to sign whatever document it is, will, power of attorney, living will, trust, or deed. Also, then I want to talk to the person ahead of time over the phone, because I don't want to make a trip out where that's not what the person's wishes actually were. You also need to make sure that it's what the senior citizen wants, not what their families want. Many of the courts recently have addressed issues such as undue influence and confidential relationships, because they want to make sure it's the person's. Generally, an adult is presumed to be competent to make a gift or make a will. However, undue influence arises when a confidential relationship exists between the donor and the donee. So it's important to be cognizant of that. Some people just want a power of attorney. So if someone just wants a power of attorney, then we will send them a separate form letter. You know, here's the draft, and when they come in, the power of attorney is either effective right away or it's effective only upon disability. Some clients ask, "What's the difference?" And we say, well, that power of attorney is effective right away. That means that they can steal all your assets right away, essentially. If it's effective only upon disability, someone has to wait until someone becomes disabled. We do powers of attorney that the banks are required to honor because we use specific statutory language. Unfortunately, someone who uses some fill-in-the-blank form that they purchase from Staples or from a computer company does not have language. It's also important that we put in our documents a Hipaa authorization. Now, Hipaa is not a big animal that lives in African rivers. It's the Health Information Privacy and Protection Act set up by the federal government to bar disclosure of medical records, so that if there's a doctor that doesn't have this type of Hipaa authorization, hospitals or doctors are barred from disclosing information. The will signing. When someone comes in to sign the will, we will ask generally a few questions. Number one, did you read the will, living will, power of attorney? If yes, did you mail or fax in any changes? Because we don't make changes the same day. And if there were changes ahead of time, we make them read the changes again. At the time of signing, let's say the person is asked, is this did you review the will? Did you read the will? Yes. Let's say, do you declare this instrument your last will and testament? Yes. It's requirement in New Jersey and most states that the person sign, then there's two witnesses, then New Jersey, to make it a self-proving will, the attorney or notary signs after that. On the day of signing, it's important that to remove the children and beneficiaries from the room, and we do not notarize something if we not see them sign it, because it's a criminal offense to notarize something in most states if someone does not see them sign it. Afterwards, we send a post-will letter to the clients. For additional information or preparation of wills, powers of attorney, and other legal documents, call the law office of Kenneth Verkaman at 732-572-0500, located at 2053 Woodbridge Avenue, Edison, New Jersey 08817, on the web at www.njlaws.com, that's njlaws.com, or www.centraljerseyelderlaw.com. Thank you and good luck.